have if you have comments, put them in the chat. But I'm Linda Hutchinson, and I'd like to welcome you to the League of Women Voters of Colorado presentation on Colorado Open Records Act. And this is hosted by the News Access and Literacy Task Force. And our guest is Jeff Roberts from the Colorado Freedom of Information Coalition. Jeff is the executive director of the coalition, and he is going to tell us everything we need to know about open records. Well, he's going to try. Okay, Jeff, go ahead.
Okay. Hi, everybody. As Linda said, I'm the executive director of the Colorado Freedom of Information Coalition. If you don't know about CFOIC, we are a nonprofit that educates the public and also the journalism community in Colorado about their rights under the open government laws. And so those are the public records laws, and we have two main ones in Colorado: the open meetings law, court access rules, and we also advocate for government transparency and press freedom. So that's our mission. And I've been doing this job for about 12 and a half years now. I spent a long time at the Denver Post as a reporter and editor. That was bulk of my career, but this is what I do now. And so I'm going to start by sharing my screen and showing you our website. So hopefully you can see that. This is coloradofoic.org. And the main things I want to show you on there. So I'm still a journalist at heart, so I write about open government issues. So we have a blog that has about, 770 articles about.
Hold out here.
I'm sorry?
Okay, so if you're not asking a question, would you please just mute your microphone so we don't get any?
Oh, okay. I thought there was a question.
No, I think so.
So there's a bunch of articles on here on the blog about freedom of information issues, First Amendment issues, press freedom issues in Colorado. The main idea is to keep the public and journalists educated about this. So one of the things we've been working on for the last year or so is trying to get the legislature to provide video coverage of committee meetings. We're the only state that still only has audio. The legislature agreed to do a pilot project over the summer and fall, and now we're waiting to see if they will extend this into the 2026 session. And League of Women Voters has worked on this with us. So we're hoping that happens. It's kind of a low-cost way they're doing it, but we think it provides better access to the legislature if they do that. And so the main thing that I do in my job is I run a hotline, a Freedom of Information hotline. I take questions all sorts of ways. I've had about 7,050 something inquiries that I've responded to. And any of you are welcome to ask me questions at any time, and I'll make sure you have my contact information. But that's a big part of what we do. But we also publish online that thing that says Sunshine Laws Guide, a very extensive guide to the Colorado Open Records Act, the Criminal Justice Records Act, the Open Meetings Law, court access rules. And I keep this up to date with any new laws that are passed that affect these areas and any case law. So when the Court of Appeals or the Supreme Court announce something that is relevant to this, I include it in there. And there's links to the statutes in here and to the case law. And you can find anything that I talk about today is going to be in here. So you can always come back and reference that. One more thing I wanted to mention before I go to my slides is that we have a newsletter that I put out by email. I don't bug people too often, usually every 2 to 3 weeks. That's kind of during the legislative session. Out of session, there's a little bit more time in between the newsletters. But if you would like to sign up for that, there's a way to do that on the website as well. So I am going to get out of this, if I can figure out how to do that. Where's the stop share button these days?
I think, I don't know, because
Let me see. Nope, that's not it. Oh, here we go. Okay, stop share. Found it. Okay, so I'm going to share again with some slides. Okay, everybody see the slides?
yes,
Good.
I can.
Okay. All right, so I'm going to start just with an example of a couple of examples of why it's important to why the public records laws are important, how journalists, other people use them. And one thing public records do is they can speak for what's really going on with government when public officials don't want to speak or they want to spin things, a certain way. So this, I think, was a good example of that. Last year,
Hey.
um, last year, the police chief of the regional transportation district was put on leave. And when a reporter for CBS Colorado asked the CEO of RTD what had happened, her answer to the reporter was, "It's none of your concern." So, the police chief is put on leave, and we're not supposed to know why. It's none of our concern. So, reporters kept digging into that, and it took quite a while, but eventually they. Is there a question?
Someone's got.
Eventually, reporters, CBS and Nine News, as in this case, were able to. I'm hearing some noises here. I don't know if someone's not muted. We're able to obtain the termination letter when the RTD police chief was fired, and there was a whole host of reasons that he was fired that the public actually probably was interested in, including driving more than 100 miles per hour in an RTD police vehicle 23 times, and improperly trying to purchase firearms with an RTD expense card, intervening in internal affairs investigations, a bunch of other things. And so this is an example of where public records, it's important to obtain the public records because the public officials aren't talking about it. And that happens a lot. Flock cameras are a big issue now all over the country. And certainly here in Colorado, I had a question from a reporter today about flock camera data. And Nine News used this data, the audit logs obtained from the Loveland Police Department to show that they had been sharing this data with ICE, which some people were not very happy about. That's been an issue in Denver as well. They where the city council has taken steps to make sure that doesn't happen. We had when during the presidential campaign, Trump came to Aurora and said he was going to start his immigration enforcement efforts in Aurora, calling it Operation Aurora, because he said the city had been overtaken by Venezuelan gangs. And in particular, a lot of people pointed to this apartment complex where there was gang activity. But the Denver Post and other news organizations used public records to show that there were problems at these apartment complexes long before all of the gang activity, and it really had to do a lot with the owner of the apartment complex. So you can use public records to just help you find out what's really going on, or maybe the story is more complex than it's being portrayed by some people. And you can use public records to show really basic stuff. Financial records of the Denver Public School District showed that the superintendent spent nearly $100,000 to remodel his office. So those are kind of like basic things that you can use with public records. Um, a little history lesson. This has been an issue since the founding fathers, that the idea that for our democracy, our self-governing democracy to work, people need to know what's going on with the government. James Madison, uh, author of the Bill of Rights and a lot of the Constitution, was the founding father who really articulated this the most. Every March, we have something called Sunshine Week now, where we celebrate um, freedom of information and your right to know. And we always put on some sort of event for that. So, where do these rights come from? They don't come directly from the Bill of Rights and the First Amendment. It doesn't mention anything about freedom of information. It talks about freedom of speech and freedom of the press. Freedom of information is sort of an extension of that, but it's not directly mentioned in there. So there are statutes, and in a handful of states, I think 8 states mention a right to know in their constitutions, but it's mostly statutory. And the statutes actually, the laws aren't really all that old if you consider how old our country is and the states. Federally, we have the Freedom of Information Act, which was passed by Congress in 1966. 2 years later, the Colorado Open Records Act, and in the 70s, the Colorado Criminal Justice Records Act. And those, as I'll talk about today, have very different presumptions of openness, the CORA and the Criminal Justice Records Act. We also have different rules that the Colorado Supreme Court has set for access to both court records and the administrative records of the courts. They are not covered by CORA. They have their own rules. Open meetings law, we've talked about in a different webinar, so I'm not going to be really getting into that today, but I'm always available to answer any questions about that. And this is from a 1983 Colorado Supreme Court ruling that it really, I think, sums up why all this is important. We need access to government information to help us vote intelligently in elections and to hold government accountable. That's what it's really all about. So CORA, the Colorado Open Records Act, as I mentioned, there is a presumption of openness in the Colorado Open Records Act. You can more or less assume that the records of state and local government that you're interested in, not law enforcement records, but all other types of records, are open for inspection, because in order to close them to you, the government has to cite something in the law, whether it's in CORA itself or in somewhere else in statute or in case law, that says that they can withhold these records from you. Either they have to because there's something in statute that says it can't be released, or they have discretion not to. A public record can really be anything that the government keeps, or somebody who is in government, like an elected official, anything that's made, maintained, or kept by them for the exercise of governmental functions or involving receipt or expenditure of public funds. So that could be really anything. It's often these days a digital record. It could be an image. It could be a video. It could be a spreadsheet. It could be a database. And it's really anything that they keep. We have a pretty good response time in the statute. It doesn't mean that governments always abide by this, but It's much better than the federal FOIA, for instance. You hear stories about people waiting months or sometimes years for records from federal agencies. In Colorado, the CORA says that the date and hour for inspection shall be a reasonable time, which is presumed to be 3 working days or less. So that's pretty good if they abide by it. If they need more time, an extra 7 days, they are supposed to explain that to you, those extenuating circumstances in writing within the initial 3 days. And those extenuating circumstances are spelled out in the statute. You could see that in our guide, what those are supposed to be. It's never supposed to be one single document that requires more time. Now, in reality, a lot of governments take more time, and sometimes you have to work with them, and you can, if they explain it to you, there sometimes you can be very reasonable, both parties, about the extra time that's needed, but sometimes it can be delayed quite a bit. So this was passed into law, not this past year, but the year before, where election records, certain election-related records, an election clerk can take longer to process those requests around election time. And the reason they did this is because election clerks had been getting inundated with records requests around election time by some people who were interested in just disrupting their operations. We had some of that stuff happening, from election denying people, and so this was passed in response to that. It does not apply. This extended deadline does not apply to journalists as defined by Colorado's Shield law. And the journalists, the idea there is that they might need the records more quickly as they're reporting about an election. So I'm sure you probably heard that there have been CORA bills in the legislature the past couple of years. There's going to be another version of this introduced in 2026. And these are bills that we have opposed. The League of Women Voters has opposed. And one of the basic things these bills have been trying to do is give the governments, the records custodians, more time to respond to records requests. So that sounds, on its face, okay, extending the 3 working days to 5 working days, the extenuating circumstances, instead of another 7 days, another, I don't remember what it was, like another 10 or so. But ultimately they could extend the time from 3 working days to more than, like, up to about 3 weeks under these bills. So the reason we have objected to this is because there's really nothing right now that records requesters can do when the government just doesn't respond to you. There's really no way you can really file a lawsuit over this. By the time you resolve that lawsuit and spent money doing that, you hopefully would have gotten your records. There was also a Court of Appeals ruling last year, I believe, that wasn't directly about CORA, but it was about very similar language in the records rules for the Colorado judiciary, and somebody sued over a delayed request, and it took months for the person to get their record, but they got their record, and the Court of Appeal said because they eventually got the record, they didn't really have any issue to sue over. So I imagine that would be the same thing if somebody sued over a delayed CORA request and it went up to the Court of Appeals. So you don't have much power there. And the other thing that I'll get to in a little bit is there are already lots of other obstacles to obtaining public records in Colorado. Fees can be a huge obstacle, and I'll talk about that in a second. and wrongly applied exemptions in the law are another obstacle. So we have felt that giving records custodians another excuse to delay the production of records under KORA is not a good idea when they already have all this power to keep you from getting public records. So that's been our argument. We're going to make the argument again. The governor vetoed last year's version, or the 2025 version of this bill, in part because it created three different classes of records requesters: public requesters, journalist requesters, and commercial requesters. I feel like, and we feel like, public records are public. There should be no differentiation. I understand the argument for journalists getting records, as quickly as they can, especially me being a former journalist, because you're informing everyone. But it still gets kind of tricky to even though there's a definition in the Shield law, it gets tricky to define that. The governor was pretty concerned about making that differentiation. The 26 bill that's going to be introduced, we've heard, does not differentiate between public and journalist requesters. And so we're very likely going to have the press and broadcasters associations with us in opposing this next year. So as I mentioned, there is a cost, or can be a cost, to obtaining public records. And in Colorado, it can get very expensive, and it can become an obstacle for getting the records that you want. So in 2014, the legislature passed a law that included a formula for what's called research and retrieval, which is the time that is spent by a government to pull the records that you've requested, to compile them, to review them, and possibly redact them before they go out to the public, go out to a requester. And so they created an hourly rate after the first hour, which must be provided at no charge. And then the government can multiply that rate by however many hours it says it needs to fulfill your records request. And so it started out at $30 an hour. The rate is tied to inflation in the law. And so in 2024, it went up to $41.37 an hour because of what had happened with inflation. And so if you multiply 41.37 by 5, 10, 15, 20 hours, obtaining public records can get very expensive. And so then the requester is forced to try to narrow their request, negotiate with the government as best they can. This really comes into play if you're requesting things like communications, emails, that type of thing.
Jeff, there's a question. Is the 2026 bill drafted yet, to your knowledge?
It is. Well, somebody probably has it, but we have not seen it. We have heard that so these bills have been previous bills have been introduced by Kathy Kipp in the Senate. We hear that the 26 bill is going to be introduced in the House by Michael Carter. But we have not seen a draft of that yet. So we don't know exactly what it's going to say. We're kind of making an assumption that that's the main thing it's going to address is the time frame, because that's what Kathy Kipp has been really trying to get past.
Okay.
So we've been advocating for several years now for the legislature to re-examine this formula on KORA fees. But we have not gotten anywhere on that. We really do think it's a problem. This is the most astounding example of a KORA bill that maybe we'll ever see. And this was just from this past March. Somebody made a records request of a library district. It was a fairly broad records request. And if she had come to me before making this request, I would have said, you need to narrow this a bit. She was trying to get information about from this library district in Colorado Springs about libraries they were considering closing. And in all seriousness, they presented her with a bill for $25.4 million. It could have been a little bit more, but she got an hour for free. So, minus 4137. But it's just astounding. So I wrote a blog about this. It's on our website if you want to read that. In Cora, there are, I think I mentioned that you can make an assumption that the records that you want will be available because to withhold them, there has to be some exemption that applies. And you are entitled to that explanation of what that exemption is if you get denied records or if they redact records. So there's a list of certain types of records within Cora that the government can withhold from you if it believes that disclosure would be contrary to the public interest. So that could be something like email addresses that people provide to government entities. It could be things like security procedures. Somebody's coming to town and there needs to be like arrangements made or something like that. There's various things that can't in the law that can be withheld from you if they decide it would be contrary to the public interest. And then there are several things in the statute and that where records must be denied to you. And then sometimes the government will cite other statutes elsewhere or other laws elsewhere in the state statutes that aren't directly in Cora that might apply to the availability of records. Some of these records have been, or some of these exemptions have been interpreted by the courts. And so, for instance, there's an exemption for users, information on users of public utilities. But there were two very recent lawsuits in Denver and El Paso County about water usage by large AI data processing centers. This is a big issue everywhere now because AI is using a lot of energy and water. And Business Insider wanted to get these records, and there was a lawsuit. There were two lawsuits, and the judges ruled that the exemption in the law did not apply. The exemption is for personal financial information. It is not about water usage of these big data centers. So sometimes it takes a judge to interpret what these mean. Some other mandatory denials in the open records law. One of them is personnel files. So what we mean by personnel files are personnel files of public employees. How do public employees perform on the job? So, go back to the police chief of RTD who gets fired, and people want to know why. There's an exemption in Cora for public employees' personnel files, but the courts have very narrowly defined what that means. It means a public employee's personal information, like their home address, their home phone number, their personal financial information. It does not mean their job performance information. So that is probably the number one thing that we have to fight governments on. They frequently cite this personnel files exemption to withhold things like termination letters and disciplinary records and things like that. And the lawyers that volunteer for CFOIC will have to write letters on behalf of journalists to say, hey, this is actually a public record. You need to be releasing this. This happened with the police chief in Elizabeth, who was disciplined and fired, and the town kept the records confidential. Nine News sued over that, and the judge said, no, this is not protected by Cora's personnel files exemption. So, we have not only some Court of Appeals rulings, but some good district court rulings where these things come into play. One big exception to all this, which is a fairly recent one that we argued against in the legislature, seems to be protecting the disciplinary records of public school administrators and probably other public school employees as well. There was a lawsuit that went to the Court of Appeals, and this relates to a provision, not in Cora, but in a different statute that makes confidential the evaluations of certain public school educators and any records that are used to prepare that evaluation. So the Court of Appeals interpreted that to mean the disciplinary records, if those are used to prepare their evaluations. And so it doesn't make sense to me that if a school principal or a school employee is disciplined for something, that you would not be able to find that out, but you could for a different type of public employee. So, this actually, the legislature expanded this protection to a bunch of other types of public school employees a couple of years ago, and we were the only ones to testify against that. It just we didn't think that was a good idea. Any questions, Linda? Okay, I'll keep going. One very frequently requested type of public record these days are emails. So reporters, other people typically want to know what's going on kind of behind the scenes, especially when you have public officials that, like I mentioned at the beginning, won't talk about something, or maybe they spin something a certain way. Getting emails and text messages can provide more insight sometimes to what's actually happening in the government. So the main thing to remember about emails and text messages, things like that, is that it's the content of the communication that determines whether it is a public record. It doesn't matter whether it's sent or received on an official account, official government account, or official government device, or a personal account or a personal device. It's the content of the message that determines whether it is a public record or not, and whether perhaps an exemption might apply, but it's still covered by Cora. So this goes back to a case many years ago that went all the way up to the Colorado Supreme Court. And it involved, and some of you may remember this, but the county clerk of Arapahoe County was having an affair with his deputy. And so the Denver Post and the Rocky Mountain News, so that's a long time ago, were interested in getting these communications between the two, which were actually sent and received using Arapahoe County, an internal messaging system. And this went all the way to the Colorado Supreme Court, which ruled that any messages about their affair were not the public's business. But if there were messages that contained both private information like that and anything about county business, they had to be redacted and the public portions provided publicly. So the salacious stuff nobody could get, but the boring stuff about county government is just fine to get. It's a public record. So that's sort of the main case law we have about this.
There are two questions now.
Okay.
One is, are the charter schools treated any differently when public records are considered protected? Considered
No,
protected?
yeah, they are not treated differently. The only, the issues with any school is, if anything discusses a student, then those records are protected by a federal law, FERPA. But records can be redacted to protect student privacy or some other, uh, uh, confidential information, and the public portions can be released. This situation with the Arapahoe clerk is one thing we point to when we argue for redaction. And there's another case called Ritter versus Jones from the Court of Appeals, where they encouraged redaction, or they said records can be redacted so that the public portions can be released. What's the
Okay,
other question?
let's see. There's two more now. In the recent incident in which some Democrats were going to an event in Vail, how was that determined related to Cora? Am I saying that, Kay? Am I reading that correctly? You want to come off mute?
Yeah, I don't know what they were able to choose. What out of the records can they use from that specific event that might determine more about what happened?
Yeah, I think that there's more possibly. I mean, from our standpoint, I was wondering about the open meetings laws that applied to that. I don't know. I mean, there could be records um, of legislators about setting up that meeting. By the way, the Independent Ethics Commission today said they were going to investigate that. So there's a story in the Sun and Colorado Politics about that just this afternoon. But you could uh, potentially Cora for legislators' email communications with um, the lobbyists who set that up. And so that's a possibility. They would have to cite some exemption in the law to withhold those from you. Uh, we're not really talking about the open meetings law today, but the legislature exempted itself from a lot of the open meetings law in 2024. So a meeting like that, which I think involved like 17 legislators and a bunch of lobbyists, prior to what they did, you might make an argument that it was considered public business under the old definition if they're discussing any kind of proposed legislation with those lobbyists. Now, under the new definition of public business in the law as it applies to the legislature, they probably don't have to worry about that.
Okay, and then with a Cora request, do they have to give an estimate of the cost?
That's something I always recommend that you ask for, and we'll go over the Cora writing letter. Um, uh, yes, if they're going to, I mean, I think that's implied because they can't. It doesn't make sense to make your request and then all of a sudden get this giant bill. They should tell you, what you're going to be charged, which they don't, they may not know until they start looking for the records you want. But that is something you definitely want to ask for in upfront, is what you're going to be charged, or at least an estimate of that. Back to emails and text messages for a second. We had a a case in Denver District Court. It didn't go any higher than that, but about 3 years ago, there was a pretty bad, maybe it was 2 years ago, there was a pretty bad hailstorm at Red Rocks, which is a City of Denver facility. 9 News wanted to get communications between the person who runs Red Rocks and City of Denver person who oversees Red Rocks during the storm and the day after. And the City of Denver claimed that these were not public records because they were on they were text messages sent and received on cell phones, and the City of Denver didn't collect those. Well, a judge said that did not matter. They were still public records because they concerned city business, and there's a way to do screenshots and to download those messages from cell phones. One of the cell phones was a city issued cell phone to one of the employees. The other one was the employee's personal cell phones, and it just didn't matter. Again, it was the content of the message that determined that whether they were public records. Autopsy reports are CORA records. They're not criminal justice records. We now have a law that for autopsy reports of minors that has been changed. We have information on our website about that. And then digital public records, and I'm talking about spreadsheets or databases. I was a data journalist for a lot of my time at the Denver Post, so I was very interested in getting an amendment passed to CORA, and this happened in 2017, that said that if you request public records that are kept in spreadsheets or databases, you are entitled to those records in that similar type of sortable format, minus any confidential fields. And the reason this is important is sometimes public records can be in databases with thousands of records. And so if you want to do any kind of analysis on that, you need access to those records in that same type of format. Before this law, what some governments were doing were just printing them out or making them into a PDF or a static PDF and making it really hard to do that. So in Colorado, unlike in some other states, the only way to challenge a wrongful denial of access is to go to court. We don't have any administrative way of doing that. You always want to, if you feel like you've been wrongly denied records, you contact me. I try to give you some strategies for pushing back on that. Ultimately, if that doesn't work and you still need to challenge this, going to court, to district court, is your way of doing that. The good news is that if you prevail, you will be awarded court costs and reasonable attorney's fees, which is really important because if you didn't have that, people wouldn't challenge the government, and we wouldn't really have any way of pushing back against wrongful denials. The open meetings law works like that too. So that what's called fee shifting is really important to have that. There is, if you are going to file a lawsuit against the government, you have to provide notice, and it's 14 days notice. And there's a provision in there that says that during that 14 days, the records custodian is required to have a conversation with you in an attempt to keep it out of court. So if nothing really has worked, the law at least says they've got to, there's got to be a last ditch effort to work this out. So writing that CORA letter, if you go back to that guide on our website, we have a template in there for writing a letter under both CORA and the Criminal Justice Records Act, and things that you want to kind of keep in mind when you're writing a CORA request letter. First, you want to make sure that you're not just asking a bunch of questions. You say, I would like to know this, 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 this. they aren't required to answer your questions. What the government is required to do is provide public records that may answer your questions. So think about it that way. When you want to make a records request, you could sit there and write out questions, to yourself that you want answered, and then think about records that may contain the answers to those questions that you can ask for. So you may not know what they're called, and that's fine. You could say, I would like records containing, this type of information. If you can be as detailed as you can, try to do that. Anything you can do to help them find the records for you as quickly as possible, because that, of course, will not only get you the records more quickly, it will keep the cost down, because they're not spending hours and hours processing your records request. Always ask for that estimate of the cost. You can say, if this will exceed $50, I want to know. And then another thing that's very important to include right from the start is if you're going to deny me any or all of this request, cite the statute that allows for the withholding of these records. And that includes any redactions of records. And if portions are considered exempt, you want the remainder of those records available to you. So you ask for that up front. In the template that we have in our guide, you'll see language for doing that type of thing.
Okay, here's a question. Awarding court costs and reasonable attorney fees only applies to denial of access to information, correct? Or does it apply to any lawsuit against the government?
Yeah, well, we're only talking about the Colorado Open Records Act right now. But if you are, say you think you were charged an exorbitant amount of money for public records and you sue over that, it's not clear cut whether a judge would look at that as a denial or not. There's actually a case in Denver District Court about that very issue right now. We haven't had a lot of cases like that, but the issue, what it's really about, is being denied public records. That fee shifting that I mentioned.
I have a question. Back on that other page, you said that if you sue because you were denied records, it goes to district court. Why does it go to district court?
Because that's what the statute says. It's in district court. It's not in any other kind of court. In Ohio, they have a special court, kind of not a lower court that is set up to resolve open records and open meetings disputes. And it only costs, I think, $25 or $50 to get your dispute resolved. Okay. I've written a couple of blogs about this because I think it's something, we might want to consider. But that's what the statute says is district court, and open meetings law also says district court. That's the venue. So we don't have a ton of more time, but I want to go into a little bit about criminal justice records, because you may find yourself in a situation where you are interested in asking for some of those, or you may wonder, how news organizations will request and get these. And there is a very different presumption of openness in the Colorado Criminal Justice Records Act than there is in CORA, in the Colorado Open Records Act. They are different statutes. They work differently. So in the CCJRA, with the Criminal Justice Records Act, there are two kind of primary categories of records. One is a very small subset of records called records of official action, and those must be provided to you. And there is a 3 working day time period for that. But that is only a really kind of a basic arrest report. It is a very small portion of criminal justice records. The rest of them, and there are a couple of exceptions now, which I'll get into, but most all criminal justice records, including things like an arrest affidavit, which is the narrative when somebody's arrested and there's a narrative, it's called the arrest affidavit. Those actually can be withheld by the law enforcement agency upon a finding that disclosure would be contrary to the public interest. So this can be a very frustrating thing for people who want to request records from police agencies, because the law enforcement agency has so much discretion to decide what to release and when to release it. So there is a case, a Colorado Supreme Court case that came out of Columbine called Harris versus Denver Post, that outlined a balancing test of interests that law enforcement agencies must apply before making this determination that disclosure would be, quote, contrary to the public interest. And so they must balance several factors, one of which is the public interest, which is why most anybody, journalists especially, would ever be requesting criminal justice records. And then any privacy interests, and then an agency's interest in an ongoing investigation, which is frequently why a lot of criminal justice records get withheld, at least for a period of time. And so I tell reporters if they've been denied to just keep asking, because an investigation is going to wind down at some point, and the public interest is always going to be there, and maybe it will rise in weight when they do this balancing test. And there is also a Colorado Supreme Court decision that says that redaction should be used to protect privacy interests in order to release as much information to the public. And I always point that out to people I try to give reporters and other people some ways to push back sometimes against these denials. And occasionally it works, or there are at least things that can be argued. So we have arrest records. Basic arrest records are easy to get. They're supposed to be released. One area that we've made some inroads in the last few years are police internal affairs records. So we actually helped get this law passed in 2019 that says that when a police internal affairs investigation, so when an officer is investigated for alleged wrongdoing, when that investigation is complete, if the investigation had to do with alleged misconduct involving a member of the public, so could be use of force, something like that, then the records have to be released once any appeals are exhausted. So that is opened up a lot of records that before 2019 were not available to the public. And occasionally we have to fight excessive redactions in those records, as we did for the Ouray County plain dealer last year. Another area that we've made some inroads on are involving police body and dash cam footage. So body cam footage is just a really important public record now. It's how we know things like, if you remember the shooting and killing of Christian Glass up in the mountains, Clear Creek County, a few years ago. This young man who pulled off to the side of the road was having a mental health crisis, ends up getting shot and killed by a deputy. We would never have known how awful that was without body cam footage. So it's just such an important public record now. And so we now have a law since 2020 that says that it sets a timetable for release of body cam footage where there is an incident of alleged misconduct by an officer. And so that's 21 days after a request was made. But there are aspects of this law that have been litigated, and there's a really important aspect of it that's in the Court of Appeals right now, which involves the fees that law enforcement agencies can charge for body cam footage. Boulder police shot and killed a woman a few years ago. News organizations and the daughter of the woman who was shot wanted the footage, and Boulder police wanted more than $3,000 for it. So, what is the point of having a disclosure law if you have to pay thousands of dollars for the footage? So there was a lawsuit in Boulder. The judge said there is no fee provision in the Law Enforcement Integrity Act, which was that 2020 bill that was passed. The city of Boulder has appealed, saying this is an unfunded mandate. And so it's in the Court of Appeals right now. We wrote a brief over the summer with the ACLU arguing that this shouldn't be allowed, that police agencies shouldn't be allowed to charge thousands of dollars for this footage. Another aspect of this that was litigated recently, and 9 News won this, the shooting of Kyla Lewis by Aurora Police last year. Aurora Police released parts of the body cam footage, but the Law Enforcement Integrity Act, says they must release all unedited body cam footage. So what does that mean? All unedited body cam footage, and it came down to when an incident starts and ends, and what that actually means. And a judge ordered Aurora to release all of it from the start, when the police were dispatched, to when the incident was completely over. So that was a good thing, and Aurora did not appeal that.
There's another question. How does the 21-day parameter to release body cam footage mix with the ongoing investigation statement? Will you still
Yeah.
get the footage within 21 days?
There is actually a provision in there that says that if the DA believes that release would interfere with the ongoing investigation, the release can be delayed until 45 days after the incident. And then the DA has to explain why that was needed. So there is a provision in there for that. And then there's other aspects of this. This has not been litigated, but I wrote a blog a couple of years ago about how there have been a few times when police have shot and killed someone, but the agency did not release body cam footage under the Law Enforcement Integrity Act, even though reporters requested it, because there had been no official complaint of misconduct filed, which seems kind of silly to me. There's automatically going to be an investigation of that, but that's what they pointed to. Usually what happens, or often what happens, if somebody is shot and killed, the family of that person will probably file a complaint, or that happens a lot. And so that kicks in the Law Enforcement Integrity Act, but it didn't in some of these cases. And so you just had to wait for when they were ready to release the footage. Another thing that we have been kind of involved in, although it's the plaintiffs in this case were the Gazette and a Chicago-based organization, trying to get the public release of the Peace Officer Standards and Training Database, which is the state licensing database of law enforcement officers. This went to the Colorado Supreme Court, and it has not been released. There's a limited version of this that's been put online. But the reason reporters are especially interested in this is to track officers who might get in trouble in one jurisdiction and move to another, and it's not easy to do that without their employment histories. So the argument was that this licensing database should have been covered by the Colorado Open Records Act and not the Criminal Justice Records Act because it's a licensing database. But that's not how the court saw it. They decided it was a criminal justice record and the AG could just withhold it, which is what they did. Jail logs are um, a, a record that it's been open for more than 100 years. You know, we're supposed to know who's in the jails. That comes into question now with what's going on with immigration enforcement sometimes. But that's a record that you should be able to check to find out who's been jailed. And then with criminal justice records, there also can be a cost issue. It's not as clearly defined as it is in CORA. There's no formula like there is in CORA. It just says that criminal justice agencies can assess reasonable fees not to exceed their actual costs for research, retrieval, and redaction. It's very difficult to pin them down on what that actually is, what their actual costs are. So they charge what they want to charge, pretty much. And then it's more difficult to challenge a denial in the Criminal Justice Records Act, much more difficult than it is in CORA, because you pretty much have to show that the records custodian did not conduct that balancing tests of interests like they were supposed to, like the Supreme Court said they were supposed to do in that Harris versus Denver Post case, you know, balancing the public interest versus ongoing investigation, et cetera. As long as they show that, it's very difficult to ever challenge these in court if you get denied, which is also kind of frustrating. Records of juvenile justice are much more difficult to obtain, as you'd expect. And you know, even if a juvenile is charged with a very serious crime, you may not be able to know information about that person unless they get actually charged in adult court, which does happen sometimes. And as I mentioned, there's a different sets of rules for court records and for the administrative records of the courts. One thing I like to point out to people, because a lot of people don't know this is available, but if you are ever interested in getting a civil court record from anywhere in Colorado, you can do that now on your computer, on your laptop, and get actual access to the records themselves. And all you have to do is sign up with the Colorado Supreme Court Law Library. And that email address is there saying you want access to what's called the RPAT, the Remote Public Access Terminal. And I use this service probably every day or maybe 4 times a week because I follow a lot of civil lawsuits about open government issues. And it's wonderful to not have to go down to a courthouse and sit there and try to find these records on their terminal. You can just do it whenever you want, and it's free. I just learned yesterday they used to make you sign up for this every 3 months, and now they're doing it once a year. So that's really nice. But it's a great service. It's actually something that they started doing during the pandemic, and they kept doing it. So that's really good. Another thing that we worked on that is fairly new and important is another thing that came out of the pandemic is the live streaming of criminal court proceedings. And so that is something that criminal courts are now required to do. There's actually a web page, which we link to in our guide, where you can go see which courts around Colorado are live streaming their proceedings at this moment. And you can tune in and watch from your laptop. So occasionally some judges don't want to do this and they defy the law. And then other things that happen, like just happened with the Morphew case, which obviously has a lot of interest. some YouTubers against the judge's order put the live stream on their YouTube feeds, which is not legal. And so the judge stopped the live streaming in the Morphew case, ruining it for everybody else. But having that has been really great for people who are interested in certain cases. It's really good for reporters who may have 20 other things to do and also have to follow this particular case, and they can do it. They can do it without having to go to the courthouse. So that's what I have on the open records laws, both KORA and the criminal justice records law. And then once again, I'd point you guys to our website, coloradofoic.org. I'm going to put my email in the chat.
Before you close out, I have one question.
Yeah.
There was legislation last year that was called Name, Image, and Likeness, something like that. And it seems to me that I recall that the problem with, well, one of the problems with it was the change to KORA laws. They exempted those. Is that what the issue was with that
Yeah.
legislation?
So this involves paying student athletes, CU and CSU, paying student athletes for the use of their name, images, and likeness. This is something that is happening everywhere now. Really good student athletes can make hundreds of thousands of dollars, maybe millions of dollars from this. So there was a bill that was passed in the legislature this past year that first of all allowed for those payments, but then it said that none of those records are public. And even though they're from public universities. And so we oppose that. And the reason we oppose that is we wanted to make sure that if there are inequities between, for instance, how male and men and women athletes are paid, if there are inequities, you should be able to examine that type of thing. If certain, say the school president's child is a really good athlete, are they getting a much better deal than some other athlete, stuff like that. So we thought all that should be out there in the public, that these contracts should be available like any other public contract. And the legislature did not agree with that. And so that is a change in KORA. Yeah, it's a new exemption in KORA.
Okay. Well, this has been more information than I'm going to retain, so I'm going to have to go back to your website. I'm glad I have all this information, though.
Yeah. I know I threw a lot at you guys. It's not, I don't expect anybody to memorize it all. And that's why we have that guide on our website. And that's also why people can contact me with questions. That's a lot of what I do. Please sign up for our newsletter, follow us on social media, all that stuff. And just know that Colorado Freedom of Information Coalition, that's why we're here, is to make sure people understand how to use these laws if they need them.
Okay. Thank you, everybody, for coming. Thanks, Jeff, as usual.
Thank you.
I'm sure we'll be seeing you again.
Okay.
Good night,
Take care, everybody.
everybody.
Good night.